Our guest today is the newly installed president of the American Bar Association. In fact, he was installed just last month at their annual meeting. He has had a long and distinguished career in general corporate law with an emphasis on regulated industries, corporate and public finance, and financial and non-profit institutions. He is a member of the Board of Trustees of the University of North Carolina and a member of numerous legal, governmental, and professional commissions and committees. He is a partner with Kilpatrick Stockton, a full-service national and international law firm with 550 attorneys. He also, for all of you, those of you who are going to work on the John Edwards campaign, knows Senator Edwards well. Ladies and gentlemen, it gives me great pleasure to introduce the president of the American Bar Association, A.P. Carlton. A.P., it's all yours. It's all yours.
Appreciate that. Thank you. Thank you, Jay. It's marvelous to be here in what I'm beginning to call my second home, Chicago, and to be with a group that has such a distinguished history in political reform and judicial reform. We're going to talk about that a little bit this morning. But first, I'd like to recognize a couple of folks myself. There are a large number of people here from the American Bar Association staff, and I won't take the time to introduce but one to you, who is our stellar executive director, Bob Stein and his wife Sandy, who are seated right here. So I want to thank them for coming. Also, the fellow who was my first speechwriter ever is here, who trained me well, I hope, we'll find out today, who is with the Illinois chapter of the American Civil Liberties Union, Ed Yonka. Ed? And one of our great friends in the ABA, who has been very active with us in seeking judicial reform nationally, Cindy Canary. Cindy? Thank you. I have to say that it's great to come here and talk about judicial reform. I want to talk about a couple of things today, but not only judicial reform. I want to talk a little bit about corporate governance, because when I travel around the country, people ask me, what's hot? And those two things are two of maybe one or two or three things more, but that's what's hot. That's what I get calls about every day and what I like to talk about. And it's undeniable that today our life is completely different socially and culturally and politically than it was a year ago. So I like to couch things in the context that post 9/11 and post Enron, we're looking at the world differently. We're looking through different lenses. And for us in the legal profession, the centrality of law has come forward, I think, in the consciousness of Americans, and we are having to be in the spotlight, and we need to explain what the law is all about, and we need to speak to issues like corporate governance, lawyers' ethics, like judicial reform, and like enemy combatants and military tribunals. Now, I won't hit you with all of that this morning, but first, just a word or two about the ABA. I like to explain what the ABA is before I start a speech. First, the ABA is the largest individual membership professional organization in the world. We have over 410,000 members. We're real proud of that. Bob knows the exact number. He can recite that. But we're the only professional individual membership organization in America over the past 5 years that has continued to see its membership increase every year. Now, that says a little bit about lawyers. I've always thought lawyers were joiners, and they are. And I've also always thought that lawyers were contrarians, which they are. But I've never been able to make those two thoughts consistent. But I think that fact does make those two thoughts consistent, that lawyers are both joiners and contrarians at the same time. In any event, it's great to be here to talk about the ABA and beyond. First of all, the ABA, when it takes positions, you should know that it's done through a national legislature of lawyers, a 535 lawyer legislature called the ABA House of Delegates. It meets twice a year. It was my pleasure to serve as chair of that house from 1996 to 1998. And I like to tell people, if you ever want to see an exercise in herding cats, come watch the House of Delegates. It's a great scene. But it is nationally representative, and it does take positions on matters of the day. And over the past 70 years, we've developed over 700 active positions on different policies. So my point is that it's absolutely impossible to characterize us based on positions we take in the House of Delegates. Every now and then we get involved in an issue, a legal matter that has some social relevance to it, and that gets us into trouble sometimes because it gets mischaracterized. For instance, a good example of that is our position on the death penalty. It has been widely misrepresented as anti-death penalty. Well, our position on the death penalty is a very lawyerly position, and as the chair of the House in 1997, it was my privilege to preside over the debate that where we took the position. Our position simply is that if the penalty cannot be administered with due process, it should not be administered at all. Now, we've defined due process in our policy. It's things like effective assistance of counsel, adequate post-conviction remedies, and the like. We took that position in 1997, and it's great to see the country kind of moving in our direction to it. Your governor here, Governor Glendening of Maryland, have both imposed moratoriums on execution of death penalty, death row inmates. The Supreme Court jurisprudence, I think it's fair to say, in the last term moved in our direction on the issue. So we're real pleased about that. I don't know where we go from here, but we are out actively pursuing moratoriums in other states. So that's a good example of the kind of position we take. The organization actively lobbies our positions in Congress, and in any given Congress we have approximately 40 to 60 issues where we lobby positions. And as you know, in most associations you have 1, 2, or 3 bet the company or bet the industry issues that people lobby on. We don't. We are spread out, but I have to say our success rate is quite good, and about 80% of the time we wind up on the winning side. Let's talk about one of the topics I think that's on the top of the agenda here in Illinois. Al Manning, our press folks, gave me this. This are the results of the judicial primary in his precinct. And I didn't count them all, but there's at least 60 or so candidates here that garnered votes. I think it's fair to say for anybody who knows anything about electoral politics that if you asked the voters what they did or how they did, they wouldn't know. I don't know if you have exit interviews like that, but we do in other states, where people in those states exercise their right to vote if they know they have it. Some of them don't even know they have it. But the minute you start talking to them about taking that right to vote away, they get very sensitive about that. And Dawn and I were talking at the table. In North Carolina, Dawn, our legislature's rejected merit selection 3 times in 15 years. So as I've traveled around the country over the last 7 or 8 years talking about judicial independence and electoral reform of the judiciaries in the states, one thing's become apparent. Well, a couple of facts first. 80% of American judges are elected or have to face the voters at some time during their tenure. So you have to work with that fact. The second fact is that Jacksonian democracy is still in full flower in this country. People like to vote for judges. We had Harris Interactive run a survey a month ago, and we asked about 5 questions about judicial elections. But the 3 really astounding responses we got were to the question of would you rather have appointed or elective judges. Over 70% of the American public said we want elected judges. Now, that flies in the face of what we've always thought is the proper way or the better way to pick judges, which is an appointive system. However, I think it speaks to one thing, and that's accountability. We went further, though. We asked 2 other questions that I thought were really, really telling. Over 70% of Americans are very concerned or extremely concerned about the amount of money in politics in judicial elections. They see the perceived impropriety of the money funding judicial candidates. The third question we asked was, would you prefer a nonpartisan electoral system? And 65% said yes. So I think what that tells us is that the American public has a real commonsensical approach to this. And that is, first of all, they like to have the accountability. If they've got the ability to vote, they want to keep that right. But second, they don't like money and politics involved in it. And third, they'd much rather have it on a nonpartisan basis. I know that there are a lot of active reform efforts here in Illinois, and we commend that to you. I had a couple editorial board visits yesterday, and they asked me about my state, and I want to talk about that for a minute because we're a test tube, and I think we're a good example of where people might be able to go. North Carolina has a proud tradition of progressive politics. We also have a split personality, as usually evidenced by the folks that occupy our Senate seats. But even within that context, I think we're proud to say that we're a progressive southern state. Once the legislature rejected merit selection 3 times in 15 years, the bar and those concerned in the state went to work. Over the past 5 years, we have taken both divisions of our trial court, and we have made the elections for those divisions local and nonpartisan. Now, 5 years ago, we elected the misdemeanor court on local partisan elections, with local partisan elections, and 5 years ago we elected our Superior Court, which is the Court of General Jurisdiction, statewide. We had 120 seats that would be voted on statewide for our trial court judges, and it was a partisan election. Over the past 5 years, we have changed both systems to where they're both now local and nonpartisan, and it has had a salutary effect on the level of rhetoric and on the level of money involved in those elections. In every capital city in America, you have one judge who gets the tough cases. The trial judge who gets the underfunded school district case for the state or all the death penalty trials. The fellow who does that in Raleigh is a good friend of mine. Wake County is primarily a Democratic county. He was a Republican, and he would have a terrible time getting elected every time he had to run. Now, in the nonpartisan environment we find ourselves in, everybody sort of went, "Whoa, boy, that's really good." No longer is he a partisan; he is a judge, and we look at it that way. So that's helped a lot. Also, we have a reform movement afoot for our appellate courts. Our appellate courts are elected on a statewide partisan basis. We're just right under the radar underneath states like Ohio and Michigan, Texas, Alabama, where you've seen multi-million-dollar campaigns for Supreme Court seats. We had our first million-dollar campaign in 2000. Again, a number of really enlightened legislators, most of them lawyers, took a look at that and said, well, we don't want what's happening elsewhere to happen here. And our Senate, on a bipartisan basis, 6 months ago, passed a bill which would provide for nonpartisan elections at the appellate level with optional public financing. It has gone to our House. The House is pretty evenly divided politically, so it's a tough act in the House, but it's been reported favorably out of 2 committees, and we expect to vote on the floor on it today or tomorrow. So North Carolina and we have the possibility in North Carolina of taking the entire state from a partisan political judiciary to a nonpartisan judiciary with public financing at the appellate statewide level, which would be a real stroke. And I've gone down to the legislature a couple of times. I used to walk those halls as a lobbyist myself, and it was great to go back, Ab, and sit there and say, this is something that I'm here to say that you ought to do, and hopefully we'll do it. But the fact is that throughout the country, independence is being threatened. The Supreme Court in the Minnesota case, if you're familiar with that, which basically stands for the principle that in electoral situations, judicial candidates have First Amendment rights too, basically is going to throw the fat in the fire. It's going to make these elections really look a lot more partisan than they really are. What we like to say as we travel around the country is that judges are different, is that legislators and executives are elected to make promises and keep promises. Judges are elected to do just the opposite, which is not to make any promises, but to keep an open mind and to be an impartial arbiter. So one of the things we like to say is that when we elect judges, we want to put Solomons on the bench and not partisans. I hope we'll get a few questions on that a little later. I'd like to move on to topic number 2, if I might. Post-Enron, the issue of lawyers' ethics and corporate governance is front and center in the American consciousness. And I even got quoted, I think it was yesterday, in USA Today with a great social comment, which I said, the social construct is changing. And the social and cultural values that we all have may be shifting to the point that we need to re-examine our ethical assumptions underlying our duties as lawyers to disclose client confidences. It comes up in 2 contexts. It comes up in the national security context, and it comes up in the corporate governance context. Let's take the corporate governance context. The U.S. Congress just passed the Sarbanes-Oxley Act. That contained in it a section which, by the way, was the result of an amendment to the bill by my Senator, John Edwards, and New Jersey Senator John Corzine, which calls for the development by the Securities and Exchange Commission of a federal code of ethics for lawyers. Now, for over 200 years, the regulation of the legal profession has taken place in the states under the aegis of the state Supreme Courts. So we are quite concerned about that. Also, the legislation contained a new standard for corporate lawyers in terms of what they do with corporate misdeeds or wrongdoing, when they discover it, and where they take it, and how they disclose it. The chairman of the SEC, Harvey Pitt, has invited the ABA into a constructive dialogue as they go through their rulemaking process on how they might develop that code for the SEC and what that standard ought to be. We have a corporate governance task force that's composed of leading experts in the area that is currently looking at the whole area, mostly with respect to corporate governance models, new independent directors and the like, and lawyers' ethics. And we will be issuing a report before the end of the year on where we think it ought to go, and we'll be making recommendations to the ABA House of Delegates to adopt policy in the area. Chairman Pitt, in speaking to us at the annual meeting, said 3 things. First, he said that lawyers need to be advertent to their public responsibilities, lest they suffer the same fate as our friends in the accounting profession. So on the one hand, he kind of shook a finger at us, but on the other, he recognized that there was a distinction between the professions right now. Secondly, he asked the right question with respect to corporate governance, and that is, rhetorically, he posed the question, who is the client? And then he answered it, and he answered it correctly in my opinion. The client is not management. The client is not the board. The client is the corporation and its constituent shareholders that lawyers represent in that context. The third thing he then said was that the commission had been dissatisfied with some of their referrals of disciplinary matters of lawyers to state bars, and that they were going to look into that, and then invited us into the constructive dialogue. We, of course, immediately accepted his invitation to enter into the constructive dialogue. Subsequently, I've been interviewed almost daily about where we are with respect to corporate governance and lawyers' ethics, and I often get the question, why aren't the lawyers in the dock? Now, with the recent TICO issues, that may change, but we may have a lawyer in the dock there. But I often get the question, you see the CFOs and the CEOs and the accountants being hauled off to jail. Why haven't we seen any lawyers being hauled off to jail? I say, well, there's a 3-part answer to that. The first answer is that if lawyers have transgressed, and that's about what's to happen, I think, they will be called to account. They will be disciplined, and they will be called to account under the criminal justice system, just like anybody else would. But they will not be called to account for the misdeeds of their clients that they didn't know anything about, or for the misdeeds of third-party professionals for whom they weren't responsible. The second part of the question is that unlike the accounting profession, the legal profession made a specific decision not to engage in other lines of business. In 2000, the House of Delegates of the ABA declined to amend our model rules of professional responsibility to allow lawyers to engage in other lines of conduct. It was called multidisciplinary practice. We rejected that, and we rejected that because, quite literally, we didn't want to go 2 directions at once. We did not want to forego some of our traditional core values, and also wanted to maintain our professional independence. Now, I don't know that we knew how prescient we'd be when we did that, but we're looking pretty good right now. The third answer to the question about why the lawyers aren't in the dock is that I call it the Freddie Prinze defense. It's not our job. Lawyers do not develop, nor do they disclose, financial data and financial information. That is expressly the province of financial professionals. Most of the problems we have seen has come from that sector of the corporate community, that sector that develops information and data on financial information, and the auditors who have the responsibility of shining the bright light of disclosure on it. Once it's out there, once it's disclosed, then it's the lawyer's job to say what happens to it and where it goes and what you do with it. But in the development phase, it's just not our job. I very rarely have had anybody challenge me on that answer, and so I continue to say it. And I believe that as long as we maintain true allegiance to the values of the legal profession, we'll be in good shape. I do think that we're going to have to completely review the underpinnings, though, as I started the conversation, the social and cultural underpinnings of our ethical responsibilities. In the end, as I started, when I started, I said, life in America today is completely different than it was a year ago, Labor Day. We're facing new challenges. The legal profession is facing new challenges. I think that it's a good time for lawyers to stand up and be counted, and lawyers to the American public. Our research tells us that the American public is listening to the legal profession. It's a once in a 2 or 3 generation opportunity for the legal profession to teach, to go out and talk to the American people about what law is all about, that it's not black or white, that it's a balancing act, and that what we do as lawyers is that we attempt to engineer the social construct in a way that achieves that balance. I hope that we make that contribution. I'm going to do everything that I can to make sure we make it. I like to say it's a great time to be an American lawyer, and I'm proud to be one. Thank you very much. Thank you. Jay indicated we'd take questions. I hope I said something that precipitated a thought or two. Thank you. Yes,
Joyce
ma'am.
Saxon, I'm on the Board of Governors of City Club.
Yes, ma'am.
You alluded very briefly to lobbying activities. Could you describe them in a little more detail? In D.C., do you have just one lobby firm, and who decides how much money to give them?
Well, thank you. We do all of our lobbying in-house. I like to say we have a fleet of lobbyists on staff. I think personnel, Bob, 8 or 9 personnel slots are devoted to legislative counsel. And so they're all ours. They're not anybody else's. Our lead lobbyist is a fellow named Bob Evans, who was the Hill newspaper ranks lobbyists annually, and in the last ranking among association lobbyists, he was ranked in the top 10 in effectiveness. And he was right there with our friends Jack Valenti at the Motion Pictures and Frank Fahrenkopf over at the Gaming Association. So we're real proud of that. Thank you. Yes, sir.
Could you comment on the ABA's position on a electoral system of merit selection where
Sure.
a panel would evaluate candidates?
Thank you for asking that question. As we become more realistic, Dawn and I were talking about this, and Ab and I have talked about it nonstop for about the past 5 or 6 years. As we become more realistic about how we view electoral systems in the state, we've come to the conclusion that the 70-year-old ABA policy, which says that we've got a one-note response for state judicial selection, we think merit selection is the way. I have appointed a presidential commission on the 21st century American judiciary. It's co-chaired by Ab Mikva and Bill Sessions. It's a blue ribbon panel of national representatives of the entire community that has an interest in this. They are traveling around the country this fall taking testimony. They're going to write a report, which will be out for comment along about middle of January. We're going to have a national colloquium at the epicenter of state judicial reform in March to discuss the matter, and that's Raleigh, North Carolina, by the way. And they will produce a report. Hopefully, part of the report will go to we'll speak to that, and we'll go to the ABA House of Delegates, and it will say, now you remember merit selection, and you remember the Missouri Plan, and yes, we prefer those, but here's the new way. Here's the 21st century way where 80% of American judges are elected. Here's what we've got to do to deal with electoral systems as well. And hopefully the ABA will then have a more realistic and more current policy. But thank you for the question. Yes, sir.
Bob Manowith, a City Club member. Should the Democrats retain control of the Senate, what hope do you have for breaking the logjam on confirming federal judicial nominees?
Thank you. That's a good question. I get that question a lot as well. Our ABA House of Delegates spoke to that a month ago. We have adopted what I call the Rehnquistian view of the world. In 1997, in his annual report to the Congress, Chief Justice Rehnquist said, and at that time the Democrats controlled the White House and the Republicans controlled the Senate, he said, nominate them and confirm them and pay them and get it over with. And let's get on down the road here. He said the same thing again in 2001 when the Republicans controlled the White House and the Democrats controlled the Senate. I think today, in today's New York Times, there's an op-ed calling for a ceasefire for the political nature of what's going on in the Senate Judiciary Committee. Our position is that we continue our job, which is we have a standing committee on the federal judiciary that evaluates federal judicial candidates. We publish those ratings to the White House, the Department of Justice, and the Senate Judiciary Committee. And you should know that we found a number of the more high-profile Bush nominees to be well qualified, including Judge Owens and Judge Pickering recently, and Judge McConnell, or to be the nominee McConnell, who's before the Senate Judiciary Committee today. We look at three things. We look at professional competence, integrity, and judicial temperament of those candidates, and we give ratings based on that. We do not get involved in the politics of the situation. We don't rate politics, ideology. As a matter of fact, we're sort of in the position of being in the middle of the traffic and watching our friends, Senators Leahy and Hatch, duel with each other about what we call the numbers judo of judicial nominations, while all we're doing is sitting there and rating the candidates. So our position is that whoever's there needs to nominate expeditiously, whoever's there needs to confirm expeditiously, and then in the end they need to be paid adequately. Thank you.
My name is Bob Downs. Could you review the current activity within the American Bar Association about the so-called TIPS proposals, the informers, and then particularly whether you believe or what is the, if any, ABA position regarding whether lawyers' conduct in any way should change from what it is now under our various ethical principles?
Thank you. We're currently, as you know, Bob, we just completed a review just prior to September 11th last year of our ethical codes, and we debated quite intensely whether or not we should change our rules of client disclosure where disclosure is allowed. It comes down to sort of a whistleblowing question, both in the corporate context and in the general context. And I can say that I believe that with respect to the two arenas that's coming up in, which is law and national security and corporate governance, I expect that we'll be re-examining that again. One of the things we have to remember, there's a history to that, and that right now, under our code of ethics, lawyers are restricted under the model code. There is a very restrictive provision on disclosure of client confidences, and it is the most restrictive provision we've had in the entire history of lawyers' codes of ethics. It was enacted in 1983 as a part of the general rewrite from the old code of ethics to the new model rules. And if you go back to the code of ethics, DR 404, which is now embodied in Rule 1.6, we had a little bit more of an allowable standard. We were able to take into account things such as significant economic harm, and as well as bodily harm and commission of a crime. So I expect that we'll be debating that, and I expect to see us perhaps take a different view of it. I don't know. We'll see. It's up to the House, and the House is 535 lawyers, You know how legislatures are. They have their own mind sometimes. But I think we're going to be talking about it. Thank you.
Given the Minnesota decision to which you referred briefly before, what on judicial speech, what are the states doing? What are the state Supreme Courts doing? Could you give us kind of an update to the extent that you know to deal with that decision and their existing codes of judicial conduct?
Don, that's a great question. I think it's going to take us a little while to see. The decision was just handed down in June. I believe that in states where we do have partisan political elections and elected judges, we're going to have to take a look at the judicial code of conduct and things like right to announce provisions that was the subject of the Minnesota case, and the provisions which prohibit judges from engaging in partisan political activity. In my own state right now, in spite of our reformist tendencies, it's sort of like the split personality of North Carolina I was talking about. We've got a Supreme Court race, hotly contested Supreme Court race between incumbent justice, who's a Republican, and a member of the Court of Appeals, who's a Democrat, both very partisan in their own ways. Both of them are currently the subject of judicial standards complaints that were filed not by litigants, not by lawyers, but by opposing political parties. One of them was for the activity undertaken by the Republican justice of presiding at a Republican rally. I mean, he's a Republican candidate. He raises money from Republicans. He presided at the Republican rally. Now, whether or not that's good taste or not, I'm not sure, but that was a week before the decision got handed down. And then 2 weeks after the decision got handed down, the Democratic Party filed a complaint against him. So the thing I'm concerned about is the fact that the partisan politicians, this goes way beyond the garden variety sort of campaign abuse where you've got issue ads that are misleading and are sham. This goes right into the process. The politicians have involved themselves in the judicial process. That's what concerns me. And I think we're going to see a lot more of that happening as a result of the Minnesota decision. So yes, I think we're going to have our state Supreme Courts are going to have to be looking at their codes of judicial conduct. We probably need to be looking, and as a matter of fact, we have a subcommittee of our Judicial Independence Committee looking at the model code of judicial conduct to take that case into account. It was a good question. Thanks. Yes, sir.
Dr. Hugh Russell, this may be a topic for another day, but what's the ABA's position on tort reform?
Tort reform. Two sort of preliminary comments about that, Doctor. One of them is that my commission on the 21st century judiciary has as a member a Fortune 500 CEO who's not a lawyer, and I insisted on a captain of industry. And when I called him and asked him to serve, he said, I've spent my whole life dealing with lawyers and lawsuits and judges and making political contribution to judges and paying lawyers and settling lawsuits. Sure, I'd love to come and talk about this. He said, can we talk about tort reform? And at the first meeting of the commission, where we were strategically positioning the discussion that we might want to have, he and several others said, maybe we need to call it something else. Because like merit selection, tort reform has become a term without a whole lot of substantive content. It's become politically charged. But in the context of product liability lawsuits, class actions, medical malpractice, I think the time has come that we need to re-examine again the bases underlying our positions on tort reform in the various contexts in which it comes up. We meet with the officers of the ABA every now and then. We'll have a joint meeting just to discuss matters of common interest with the officers of the American Trial Lawyers Association. And we had that meeting a week ago. And one of the things they asked us to do was to take a look at our existing policy and at the reports underlying that. We had two commissions in the late 80s that looked at it, and they issued great reports that have become texts that have become great reference works for people in that area. One of them was the McKay Commission, and the other was the Hewitt Commission. And I think that we're probably looking at the proposition of updating those reports at the very least. And when we do that, the ultimate result of that will be looking at whether or not we want to change any of our policies. Thank you. I hope that was a long-winded answer, but I hope I answered your question. Yes, sir.
Jeff Berkowitz, host and producer of Public Affairs,
Yes, sir.
airing every Monday night at 8:30 on Channel 21 throughout the city of Chicago. CAN TV.
And as I recollect, you and I are going to get together to tape
We're going
an
to tape
interview
you tomorrow night, and that'll air on October 7th, I believe, in
Yes,
the
sir.
city. Okay. I wondered, you've outlined various reforms regarding the way in which we select or elect our judges on the state level. But I wondered if you could say how those reforms might improve the way in which either a body or the public assesses, analyzes, and then acts on that information about the judges' performances.
Thank you. The ultimate end game and the objective of electing judges in a fair and impartial way is to get judges who are viewed by the public as fair and impartial, and to maintain the public's trust and confidence in the judicial system. The only asset that our judiciary has, as it goes back to the Federalist Papers, has neither the power of the purse nor the sword. The only asset they have is their ability to persuade and to reason and to convince people of the power of their judgment. And if the public does not have trust and confidence in that judgment, then we've got a very difficult situation indeed. So the ultimate objective of the discussion is to keep or improve the public's trust and confidence in its judiciary.
But how will this work? That's what I understand the goal and the objective.
That's the goal.
But how does that work?
There's a linkage between the way we select judges and whether or not the public has trust and confidence in the judiciary. When we talk about the effect of campaign finance in those states where we have partisan political elections on the public's view of the judiciary, there's a direct link between how they view the judiciary and whether or not they are truly impartial. And we have a number of surveys in a number of states that indicate that the public perceives that there is an impropriety in judges taking campaign contributions from people who appear before them or people who have matters or cases before them. And that impacts directly the public's ability to see the judiciary as something they have trust and confidence in. What our objective is, and the techniques we're talking about, lower the likelihood that the public is going to view that as a perceived impropriety. What we're trying to remove is the perceived impropriety that results in the public viewing the judiciary as perhaps not being impartial.
Well, one short follow-up.
Sure.
Are you also concerned with whether the suggested changes in the process may affect favorably or unfavorably, not so much the perception, but the actual selection of judges? That is, will it improve and make our selection of the right judges, so to speak, better?
I believe that if you have a system that gets you an impartial judge, it will get you a qualified judge. And I think that the public will understand that through voter education guides and the like, is that they have to view a judge's candidate. And this goes back to qualifications. If you want, we'll get back to qualifications when we talk later, if you'd like. But, okay. Thanks. Yes, sir.
I'm interested, does the ABA have a position on the current problem of the immigrant, I think the Justice Department calls it administrative adjudication of some sort?
Our House of Delegates, its meeting last month, took a position on what we call enemy combatants, either in the immigration context or in the citizens context. There's a good bit of detention of folks going on in America today. The policy we have speaks to folks who are detained in the United States and who are either immigrants or entitled to protection under our laws or citizens. And our position is that they are entitled to assistance of counsel and a right to a judicial hearing. There are 3 or 4 cases in the court system right now that will, I think, give us some judicial definition on that very soon. Okay. You're it, Yanka, last. Yeah.
then I'll hurry. I just will say, AP, that it's clear to me that you have upgraded not only in position but speech writers over the years as well. I have two questions that are a follow-up to two things that you've mentioned about judicial selection, both at the state level and at the federal level. At the state level, we have a lot of elections around the country that are awfully partisan for nonpartisan races, and I wonder how your proposal addresses that question. And secondly, I wonder if you could just tell me your reaction to the view that both sides of the aisle in the Senate now seem to view the ABA Judiciary Committee recommendation as, quote, the gold standard, and where a few years ago the administration, or a year ago, this administration threw you out of that process.
Okay, well, I'll take the second question first. Actually, we didn't get thrown out of the process. For 50 years, our part of the process was that we were partnered with the administration, and we were behind the curtain before the nomination was made public. We rendered our evaluation to the administration for the administration. What the Bush administration did was uninvite us from that position. When that happened, we stopped the trains and went and talked to everybody who had a role in the process and said, what do you want us to do? Lo and behold, they all said, keep doing what you're doing, just do it after the nomination is made. So that's what we do today. So I think what has resulted in is that we're now far more publicly involved in the process. It's now clear to everybody that you can have two judges with diametrically opposed philosophical points of view or ideological points of view who can get well-qualified ratings, because all we look at are those three criteria I talked about earlier. It's really kind of fun after all those years of being characterized as favoring one kind of judge or another to introduce both Senators Hatch and Leahy to a group of ABA leaders, which I did 3 months ago, and they sit there and throw bouquets at the ABA for the work we're doing for them and then point fingers at each other. So right now I think we're in a good place on federal judicial selection, and I think we have a great impact, and I think we'll continue to do that. The second question, the first question, which we'll answer second, is a lot more difficult. As you know, the different systems around the country are it's like a patchwork quilt. But where you have truly nonpartisan elections like the trial bench in my state right now, and the parties have no involvement at all, you see an improvement. You see the level of political rhetoric come down. You see the level of educational rhetoric as to the judges' qualifications, the questions like we had over here about who needs to be a judge and who is a good judge come to the fore. So it's sort of for instance, there are a lot of systems that say they're nonpartisan that aren't. For instance, over in Michigan, they say it's nonpartisan, and when you vote, there's no party identification on the ballot, but to get on the ballot, you have to be nominated by a party. So you have to look at each individual system and try and figure out whether they're truly nonpartisan or not. Okay, Jay, thanks.
That was wonderful. I forgot to mention, for those of you who are interested in politics, his former law partner is Governor Terry Sanford. So on another day, it'd be interesting to hear him talk about Sanford, Jesse Helms, John Edwards, and how such a thoughtful young guy like him.
My other partner was the first Republican governor in the 20th century in North Carolina, so we were bipartisan, I might add.
Well, that's good. In Illinois, we say hate the sin, but not the sinner. Anyway, on behalf of the Board of Directors of the City Club of Chicago, to AP Carlton, this membership to the City Club, and this, too, is within all the ethical guidelines that you pass weekly, a mug to the City Club of Chicago. Thank you to AP Carlton. Thank you. That was fun. That was very well done.